Medical malpractice is a negligent act or omission by a healthcare provider that occurs during the course of him providing professional treatment. It can be anything from a misdiagnosis. It could be anything from the slip of a knife during a surgery. It could be an administrative mistake. Sometimes you hear about the horrific incidents where somebody took the left leg off instead of the right leg. Medical malpractice is professional negligence by a medical provider that the law provides a remedy for to the injured patient, and that remedy being compensatory damages to compensate the victim for whatever their loss or suffering might be. In your medical malpractice cases, there can be a number of potential defendants that could be liable for a person's injuries. It could include the treating physician. It could include a diagnostic physician reading x-rays or looking at MRIs. It could include nurses who didn't put the right pills in the right cup or didn't administer them when they were supposed to. It could be a hospital. So there are a variety of sources, all of which are recognized as healthcare providers. And to the extent that they actually provide medical treatment, then they could be liable for whatever injury or damage they cause. A client who has suffered a medical incident is invariably extremely disappointed because they put a lot of trust in their treating physicians, and rightfully so. They're not only disappointed, but of course they're upset and outraged that instead of leaving the doctor's office or leaving the hospital better, they left worse. Invariably, they're looking for another physician for starters, because if it's a medical injury, you still have to have a treating physician to remedy that. And of course are a little skeptical about dealing with any doctors at all, given their past experience, but you have to assure them that there are very good doctors in the area and you just find them the best treating physicians that you can, which is what we routinely do. Most medical malpractice cases do not go to trial. It's actually a relatively small percentage that do. With the advent of mediation, which came about 10, 15 years ago, there are a lot of cases now that are settled without trial, because now there's this intervening step that's now mandated by the courts because it's been so successful. So you have to mediate. A responsible attorney is going to try to settle a client's claim anyway, because typically when you settle something, then the attorney's fees are less, the costs are less. So you do everything you can to maximize the net result to the client. A person who succeeds in proving that there was medical negligence is entitled to personal injury damages, pain and suffering, mental anguish, loss of capacity for enjoyment of life, disfigurement, permanent impairment. And in addition to that, there's medical expenses, past and future, and there could be a wage loss component, again, past and future. If somebody's unable to work anymore, then there's a future earning capacity that needs to be valued and hopefully recovered. This firm has been doing medical malpractice work since 1979, and we've handled quite a few medical malpractice cases and are very conversant. Medical malpractice cases have nuances of their own that somebody has to be familiar with. The doctors over the years have convinced the legislature to put all kinds of protections in there so that the claims that are ultimately pursued against doctors are practically pre-proven before you even put them on notice of a claim. You have to have the medical records. You have to have them reviewed by an expert in the field. You have to have a written opinion that medical negligence did in fact happen. Those are the pre-trial procedures that have to be followed before you can even commence a medical malpractice claim. You need somebody familiar with those procedures as well as the trial process that follows. What makes our firm different from other firms is that we are local. We've also practiced throughout the country in both state and federal courts. We are passionate about representing our clients. We take an interest in them. Many of our former clients are friends to whom we communicate with to this day. Client communication is critical. We return telephone calls and emails promptly, because a client should never go long at all waiting to hear what their attorney is doing. We are a small firm, and the advantage of having a small firm is I personally work on your case. Mr. DePaula personally works on your case. Your case and the preparation of that case, the appearance at court, trials, writing of appellate briefs, those are handled by the two of us, not someone else, not a paralegal, not a secretary. During a prospective client's initial consultation for a medical malpractice case, we review the circumstances. We try to gather as much in the way of medical records as we can in advance of the meeting so we can try to understand what happened. We discuss with them the panoply of damages that could be available to them. We try to tailor that down to what we think realistically comes into play for them based on what we know at that point in time. We caution them that that's always subject to change as the case develops. We explain to the client that medical malpractice litigation is time-consuming, it's taxing in the sense that it takes a personal toll on people. So you explain all of that to the client, but more importantly, you try to educate the client as far as what they can expect, as far as the process that they're about to embark upon, and what they can expect every step along the way.